As is our custom, we start with the Pledge of Allegiance. If you could stand, join us, please. Pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all. Thank you. We have 3 items on the agenda this evening. Appeals 2969, 2970, 2971. In order, it's Midland Avenue, Garrett Avenue, and then County Line Road. That's the order that we'll be taking them. And we will start with Appeal 2969, if the applicant and their counsel could step forward. For the record, the applicant, Kara Hanlon Arnold, property located at 401 Midland Avenue and zoned R2, seeks a variance from section 280-20.c and sections which follow of the code in regard to front yard setback requirements in order to construct an addition. This matter is continued from June, even though it's a continuance from June, Council, as we've indicated to you. 2 or perhaps 3 of the members of the board are here tonight. We're not at the meeting on June. You have revised plans, so we would ask that you essentially take us from step 1, not build on what you presented back in June, but just present the case fresh.
Understood. Thank you, Mr. Martin. Good evening, board. Scott Rothman. I'm the attorney for the applicant, Kara Arnold. I'm sorry?
Speak into it.
Yeah, no problem. As a matter of housekeeping, can we first decide if we are using exhibits that were marked last time? I understand that this would be essentially an amended record because we have new submissions, and I think it would be good
What
to
we
get
do is we put, I would think, is we kept the exhibits, and we just, if you have new ones, then we start adding them, in sequence after the ones from last hearing,
Okay.
numerically from the ones added.
Do we know what the final exhibit that was submitted during the June hearing was in terms of identification?
I believe we had 10 exhibits that were admitted during the hearing, and since then we have new submissions, obviously including the revised variance drawings, as well as a new summary of requested relief, a new summary of improvements, some letters of support from neighbors.
Okay, well, to the extent materials were submitted in June and you're aware that they were, you can refer to them, to the extent you know, in accordance with their identification from June. As you have new items, please identify them sequentially, and we'll start with A11.
Okay, great. So why don't we get that out of the way first, just as housekeeping, just so we all
Yes.
have the record clear. So I'm going to mark as A11, and I believe the board all has a copy of a letter from a Mrs. Virginia Devine. And that letter is dated July 18, 2006.
This was in front of my spot. Do all the board members have a copy of that? Yeah. Thank you.
The board has the Ms. Devine letter?
We have the A11 letter, yes.
All right, and then I'm going to mark as A12 a letter, it's undated. It's from a gentleman named Glenn. I'm not sure if I'm pronouncing it right, but it's Bernabeo. Bernabeo. We believe that was submitted to the board as well.
I don't have a copy of that. Do you have a copy of that letter?
Okay.
Thank you.
That'd be A12.
Okay. And there was a third letter from a Mr. Nichols, which was emailed to the board as well, and I'd like to have that marked as A13 and have the board confirm they have that correspondence.
Don't have that letter either.
I do know a letter was received by board members earlier this week. Does staff have a copy of that letter?
I don't have a copy here. I have the last one from Glenn. I don't have
We have the A12 letter. Do you have any copies of the A13 letter with you? The members have seen that letter, and as you go through, it would be helpful, if the individuals who provided the letters are not here, it would be helpful at some point if you could point out to us on the plans the homes of the individuals who have submitted letters.
We can definitely do that. So by way of background, this is an application by Kara Arnold, the record owner of 401 Midland Avenue in Radnor Township. Kara purchased this property with the intention of improving it and moving in with her family. Kara has 4 children. The property currently is in an uninhabitable condition. Kara has made many preparations to begin improvements, but we need this relief tonight before the board to apply for building permits and other permits to do so. Before the board tonight is an application pursuant to Section 28145 of the code, which sets forth the requirements for a variance. And the specific variance tonight we're seeking is dimensional in nature, and it's the variance, it's for the setback under Section 280-20, subsection C of the code for front yards. There's actually 2 front yards as defined by the code on this property since it sits on a corner. It sits on the corner of Midland Avenue and Pembroke Avenue. Currently, the main facade, the front of the house faces Midland Avenue. And what we're proposing is an addition essentially to the rear of the house along Pembroke Avenue. The front yard setback under the code is 40 feet, and that's the applicable setback, and that's the setback that we're seeking relief from. As the board knows, there are 2 standards for variances, one of which is you have to demonstrate a hardship. We're going to submit proof tonight through testimony from Rebecca Lauer, the architect and design professional, and Ms. Arnold, about the hardship posed by the irregular shape of this property, which is necessitating the variance relief from the front yard setback. The other variance that we'll submit for the board's consideration is a de minimis variance, which the board has wide discretion to find, and that actually renders moot the need to prove hardship. And we believe in this instance the relief is essentially 79 square feet in nature when you look at the expansion of the existing nonconformity, which I'll get to. The owner by right could construct a detached garage on this property, and we'll have testimony tonight as to what can be done by right and why that is a more intrusive option for the property itself and for the neighborhood as a whole. And that's going to be an important thing for the board to keep in the back of its mind as to why we're proceeding with an addition onto the property rather than a by right detached garage structure. I'm going to ask Ms. Lauer to turn to the
If I could interrupt you, if you could approach me and take the Bible here and the microphone, and the stenographer will be swearing you in. Now, you can return over there.
Left hand on the Bible, right hand. You solemnly swear the testimony you're about to give will be the truth, the whole truth, nothing but the truth.
I do.
And state your full name, please.
Rebecca Fellerman Lauer, licensed architect in Pennsylvania. I work for
Spell
Asher,
Lauer for me.
Lauer, and I work for Asher Associates Architects.
Thank you.
Okay, Ms. Lauer, the plans that we're showing that have been submitted to the board and that are on view, did you prepare these plans?
I did, yes.
And have you visited the property known as 401 Midland Avenue?
Yes, several times.
Okay. And what is your...
Counselor, I don't think we've entered these. These are the new plans that we received.
These are the revised plans, yes.
So we should probably label those A14, and we can refer to the individual sheets.
All right, Ms. Lauer.
Yes.
Can you describe what your role is in regard to the proposed historic restoration at 401 Midland Avenue?
Yes, so I'm the architect and designer working on not only the addition, but on restoring the original home that we're expanding with this addition.
Okay. Did the plans that are shown on the overhead indicate the footprint of the addition?
Yes, so the dark line that you see, as opposed to this lighter line, the lighter line represents the existing home, and then the dark line represents the area we're expanding. The gray area on your sheet is the 79 square foot of the encroachment onto the expansion of the existing nonconformity toward Pembroke Avenue.
Okay. And just for orientation's sake, does Midland Avenue run which direction?
Pembroke runs more or less north-south, and then Midland meets it, at an angle.
Okay.
So east-west.
And can you clarify for the board where the two front yards are, at least under the code?
Yes. So Midland Avenue is one front yard. As a corner property, Pembroke is also a front. The house's front door is oriented toward Midland. So architecturally, the front of the house faces Midland. There's a rear yard opposite Midland, and then opposite Pembroke is a corner lot. It only has one side yard, which is the long yard opposite Pembroke.
Can you identify where the property boundary line is along? Can you identify for the board where the property line runs along Pembroke Avenue?
Yes, so the property line runs down the center of Midland and Pembroke. The right-of-way line is this line inside of the sidewalk. And then from there, the legal setbacks are here arcing well into into the existing house, and here where the existing house passes as well. The second line that you see further out is the closest approach points at the side yard and at Pembroke for the existing house. So those are the existing nonconformity lines, here and here.
Ms. Lauer, have you reviewed the applicable provisions of the Township Code?
Yes, I have.
Okay. And are you aware of whether there is an existing nonconformity along the Pembroke Avenue front setback?
Yes, there are several existing nonconformities. On Pembroke, this entire area of the existing house is over the front yard setback line. This area of the existing house is over the side setback line. And in addition, there's an existing shed, which we'll be removing, that does not meet the accessory building setbacks in the rear side corner.
And what is the shortest dimension of the existing nonconformity setback?
So the closest approach point to Pembroke at the house is 26.4.
Okay, and is that measured from the existing house?
That's measured at this corner of the existing house to the right-of-way line along Pembroke.
And does that measurement run essentially perpendicular to the right-of-way line?
Correct.
Okay.
All the measurements are perpendicular.
Okay. Now I see you have a dark gray shaded area, and it looks like the term new entry and new porch is written inside. Can you explain what that area signifies?
Yes, so in our previous submittal, the addition consists of an attached 1.5-story garage and an extension of the existing rear 1-story portion of the house to connect to that garage. Previously, the garage also expanded the existing nonconformity. We've pushed the garage back so that it aligns with the existing building wall on the side yard. And that has significantly reduced the amount along Pembroke that we're encroaching. So this gray shaded area consists of a small open porch and a new enclosed entry from that porch into the addition. And we've gone from In the previous submittal, we had over 202 square feet of encroachment, and these two gray areas together are 79 square feet.
Now, I recall from the last proceeding with the original plans that the side yard setback, we were not as close to that side yard as we are currently.
Correct. In the previous design, we were keeping the back of the addition within the building setback line. In this proposal, we have brought the new garage proposed to meet the existing house line. So there's no expansion of the existing nonconformity in the side yard.
Okay. And why was it necessary in this revised plan to push the addition back toward the side yard?
It was deliberately done in order to reduce the amount of encroachment along Pembroke,
To minimize
to
the,
minimize the expansion of the existing nonconformity.
along the front setback?
Correct.
Now, if you tabulate the nonconformity area posed by the shed that's currently on the property,
Yes, so the shed is 123 square feet, and that's an existing nonconformity that we're removing. So the new expansion is significantly less than what we're removing.
so does that mean you're actually having,
The
There's
net,
not a
the
net-
net is
okay.
actually, we're reducing the nonconformities on the lot, even with the small addition.
okay. Can you explain for the board, given that you've been to the property, what the current condition of the house is?
Excuse me. Yes, so the existing house had structural issues that required immediate repair that Ms. Arnold has already undertaken. In order to do that, we had to investigate the existing structure to determine what was causing the problems. So we have had to remove ceilings, remove portions of plaster to get at the wall structure in order to investigate and then design a solution for those repairs.
And can you explain to the board, even though we're not here on an application for any permits to build, what are the plans? Why do we need to build an addition onto this house?
So the existing one-story addition of the house packs a lot into it. There's a porch, an entry, a mudroom, a breakfast room, a laundry room, a powder room. The powder room, you actually have to turn sideways to get inside of it. It's incredibly tight. So we are expanding that section of the house in order to have all those same functions, just slightly more generously sized, and to connect the garage to the house. So in inclement weather, Ms. Arnold and her family can park and come into the house through that garage. There's also a playroom over the proposed garage, so that that's actually steps up from the first floor, and that allows more family interaction. That's something the house doesn't really have. It doesn't have any sort of play space for family room for children.
I see a driveway on these plans. I'm assuming that goes up to a garage, right?
Correct. So the existing driveway is represented here by the dashed lines, and the new driveway is here. Currently, there's only 2 parking spaces on the lot. We're proposing 2 at the driveway and 2 within the garage, so we're doubling the amount of available off-street parking on the lot.
Okay. Can you discuss the impact on impervious coverage of building this addition and, I guess, building a new driveway?
Yes, so our impervious coverage, we're still well below the maximum allowed. We're 386 square feet below the maximum, even with these improvements.
Are any trees or other vegetation being affected by these proposed plans?
Yes, there's a tree here at the new driveway that will be coming out. There's several trees here at the rear proposed patio and garden area that will be coming out. And there's another tree here on the front.
Is it feasible to construct an addition of the kind that Ms. Arnold is proposing without expanding the existing nonconformity along Pembroke Avenue?
It's difficult because of we're trying to respect the existing historic house and impact it as lightly as possible. That's why we are extending the existing one-story portion at the rear. If we were to get all of the program, all of the items, the wish list, into this footage, we'd be basically filling this entire rear portion of the house, blocking a beautiful handmade historic window here, changing the scale of the addition to the existing house. From a historic preservation standpoint, it would really negatively impact this house if we were not to go in and propose this. The idea here is there's a main house, an extension of the existing one-story piece connecting to a carriage-style garage, as if this house had evolved naturally over time.
Have you taken these plans before the Township's Historic Architectural Review Board?
Yes, we received an enthusiastic certificate of appropriateness from the HARB. We'll be going back to them August 3rd with these proposed changes just to get there.
And just for clarity, when you were before HARB previously, was it for these plans or for the original?
The original plans, that's why we're needing to go back in August for these revisions.
Okay, so the board can be assured that if they grant variance relief, that you nonetheless still have to take the revised plans before HARB?
Correct, that is our understanding. And we've already submitted that application.
I'll open up the questions to the board.
Yeah, just one quick point of clarification. If you could go to sheet V3.
Yes.
All right. I guess I'm just a little disoriented. 401 Midland,
Yes.
and then what is the parcel in red that is indicated as that is labeled as 404?
This is from the tax map, so that would be the lot and block.
Okay, so
It's not
that
the
is the
address.
parcel that we're talking about?
Yes, that is the parcel. So it's the
All right.
tax map, the quad map, and the aerial view, but the lot and blocks are different from a street address of 401.
If Pembroke did not have the jog in the easterly direction
Right, if it
that
didn't curve into
has,
the lot.
do you believe that you'd be able to build an acceptable addition without increasing the encroachment?
Yes, because, if it was a rectangular lot, which is what the code assumes, and came straight, the right-of-way came straight back, the 40-foot line would more or less miss the addition. So yes, that would make a huge difference.
Do members of the board have questions?
Maybe just go into a little more detail on the geographic hardship here.
Okay, and on the curve of Pembroke
Yes.
into the lot? So, can I mark on these as an illustration? Okay. So, basically, if I were to square off the lot, this is the 40-foot line, and you can see as I draw it back, it misses both the existing house, so there would be no existing nonconformity, and it also misses our addition. There would still be an existing nonconformity along the side yard because the existing house is built too close to that. It's a 20-foot setback there, but certainly if this was a squared-off lot, the right-of-way going along here, straight back, perpendicular to Midland, and then the setback line here, you can see the impact of it. There would be no existing nonconformity along Pembroke, nor an expansion of one.
Matt, did you have a question?
I want to show a drawing. We can mark this as A15.
Do we have this drawing yet?
This is the only copy I have.
This is just for illustrative purposes, because this is not what we're proposing, but it's just to show what could be done by right under the code with regard to a detached structure. And I wanted Ms. Lauer to explain.
I would ask you not to. Technically, I don't think it's relevant.
Okay.
And I don't think it's necessary. What I would like you to do, if you have it, if you have a diagram or even a photo that provides the property in some neighborhood, in context of the neighborhood, and then if you could take the time to point out to us the locations of the residents who have submitted the several letters of support that you've had introduced.
So first, let me show you both on the site plan and on this where the neighbors are. Okay. So here is our site with the star. Here is Pembroke, and here is Midland. The neighbor along the side yard is Mr. Nichols. That's the letter that was emailed directly to you. He's in support of the project.
What is Virginia's last name?
Divine.
Ms. Devine owns this property abutting the rear yard of our property. She is also in support of the project.
For the record, could you identify the letter and also the sheet that you're referring
Certainly.
to?
So I'm looking, this is sheet V2.
Mr. Nichols is A13.
Okay. So letter A13 exhibit is House E.
A11.
Letter A11 is property B. It's this, it's a commercial building shown in this photograph. And then the A12, letter A12, letter of support, is directly across Pembroke here. So all neighbors directly abutting the rear of the project are in full support. I would also like to show the addition is, this is the view of the house from Midland. This gray shaded area is the only portion of the addition that sticks out past the existing house. It's very, very tiny from Midland. I would also point out that from Midland, this is the view of 401 Midland taken from directly across the street. There is a large tree, so there is no impact of the addition from the front, from Midland. In fact, you can barely see the existing house when the tree is in leaf. So from all neighbors that would be looking at this addition are in support and have submitted letters accordingly.
And again, for the record, that was V8 that you were
Yes.
referring to?
Yes, V8 has existing views to and from the site. So we should make that an exhibit, because these are some of the new
These are
sheets.
already,
Oh,
they're,
you have them in your packets.
they go in the packets. It's
Okay.
the A, whatever the number was, and then you put in paren V1, paren V2, paren V.
There was, the diagram you started this reference to when you were showing, yes, if you could leave that there, because it may be helpful if other witnesses are testifying, so that they can provide us context. Counsel, is there anything else that you have for us in terms of your
I'd
presentation?
just like for Ms. Arnold to be sworn in and give a brief statement about her plans and why she believes there's a hardship.
Fine.
You just raise your right hand. You do solemnly swear the testimony you're about to give will be the truth, whole truth, nothing but the truth.
I do.
And state your name again for me.
Kara Hanlon Arnold.
Thank you.
I think Scott did a great job of explaining why I'm here. I bought the house with the hopes of living in it. I do have a number of children, and am a Wayne native, a Radnor grad, always wanted to live in South Wayne. I grew up a few blocks west, so this is a little closer to the center, and bought a house knowing that I was going to restore it. It's what I do. I'm an interior designer by trade. I love houses. I've worked with Rebecca before, and so we knew this house with its structural issues, but it's with its original details, could meet the needs. So that's really why I'm here.
Can you just explain to the board why the addition is going to improve the property?
Well, the existing bump out that's there is not, it's early but not original. And because it was not, a lot of things were crammed into that area. So it's a kind of a warren and not the most productive space. Also wanting to put in a garage on the property just for cars and cars off the street, because Pembroke does back up to Lancaster and there is traffic on that road quite a bit. And in exploring the best ways to do that, the detached garage was much more impervious, much more impact to trees, and then obviously the convenience of being closer. Also from a design thing gave us a connection that looked more historic. So that was where we went with that.
Anyone on the board have any questions of Ms. Arnold?
Ms. Arnold, you adopt as your own the testimony of your counsel and
I
your
do.
architect?
I do. Thank you.
Okay. Rather than
Thank you.
do oral argument, I'll just rest on the legal memo that was
Okay.
submitted to Mr. Ryan.
Thank you. Are there members in the audience who would like to speak to this application? And if they are, could they please come up? introduce themselves, we'll swear you in, and then you can provide whatever testimony you would like.
Promise to tell the truth, the whole truth, nothing but the truth.
I do.
And state your name, please.
My name is Samantha Phillips Beers. I live at 402 Midland, which is directly across the street from 401 Midland. And I have a view of the entire front of that house that wasn't really shown here. So I have a couple things to say. And the first thing is, I did appear at the last hearing as well. And I want to start by saying I appreciate the fact that Carl wants to live in downtown Wayne. That's why I live in downtown Wayne. I've lived in Radnor since I was 27, however many years that was. And I've lived in a bunch of different houses. I've been in this house more than 10 years, and I knew the Gallaghers until the day they actually moved out. I actually helped them finish carrying the stuff out, and they were living in this house. So I'm unclear about what makes it habitable or inhabitable, but I'm just a lawyer. I'm not an architect, so gosh knows what that was. I also really appreciate the fact that a historical architect's involved and is actually trying to preserve the nature of the house. Many of us moved to downtown Wayne because we want to walk around the sidewalks, and we like the fact that there's zoning rules that help things look substantially similar. Things have changed in the neighborhood through the years. We've watched a lot of additions. And when it's my husband's turn to speak, he brought pictures of some of the additions in the neighborhood that are really in alignment with the character of the neighborhood and helps give you a little bit of an idea. I think sometimes we drive through neighborhoods instead of walking through them, so there's little subtleties that can be missed in terms of getting the feel for a neighborhood. And I happen to be a walker. I walk to and from the train. I walk my dogs. I unfortunately chase them sometimes when they escape from my house, which has been known to happen. But I'm a big walker. I walk to the movies, I walk out to dinner, and I really appreciate the sidewalk elements of Wayne. And frankly, one of my significant concerns here is the encroachment towards the sidewalk. I walk to Lancaster. I don't want to feel like I'm in someone's yard, and I don't want to feel like a 36-foot addition. I'm 5'3", so a 36-foot double addition hanging over that close to the sidewalk would color my experience. So the standards, as were stated by the attorney, are hardship and de minimis. I would argue I'm not seeing a hardship, I'm seeing a wish list. And I understand you bought the property from the Gallaghers and you want to fully enjoy it, and we embrace that. We love having new families move into the neighborhood. We think it's wonderful for the vitality of the neighborhood, and I look forward to having a really wonderful relationship with all of my neighbors. But I'm not sure it's a hardship to say you'd rather have something attached and it needs to bump out because 76 feet is less than it could have been if I did it the other way. I wanted to do it when I bought the property. It's not as if the road just suddenly curved. The road's been curved for over 100 years. So when you went and looked at the property, you knew that you were backing onto a parking lot from a commercial building, right, that's currently being partially leased out to the Jaguar dealer. So it's not like there's a neighbor back there who's saying, I'm barbecuing. It's not. Ms. Devine. So you have this parking lot area, and then you have the sidewalk that we walk on. So my significant concern is the sidewalk issue. I appreciate the fact that they've done work to minimize it from the last time we came in front of you. I know some of you weren't here, some of you were, but they've done a great job of that, and I applaud it. But I think it's disingenuous to say that for someone like me, because I didn't write a letter saying I don't care, do whatever you want, that I'm not affected by it. I am affected by it, and it's not de minimis from my perspective when I'm walking on a sidewalk within 19 feet of a 36-foot structure. Plus, if you ever walk around my neighborhood, and I think it's a great idea for everybody to walk on the sidewalks, that's why we have them in downtown Wayne, you will notice that there are, I walk twice a day with my dogs, I'd say less than 5 houses with attached garages, which is not to say don't attach your garage. Do whatever you want to do within your envelope. You want to attach your garage? That's not in the character of our neighborhood, but you should live and be well. But when your attached garage lessens my ability to enjoy my sidewalk walks, which I do every single day, rain or snow or sleet, because I have dogs, that's something to me. I'm not sure where the hardship is, which is part of the standard. I don't think they met their burden. I just don't. And as the person who lives directly across the street, my enrichment, my enjoyment of a neighborhood that I moved to, in part because I wanted to walk everywhere, will be diminished by a 36-foot structure, 19 feet from the sidewalk. Thank you.
Hold on for a second. I'm sorry. Just I want to see if any of the members of the board have any questions. And all council, do you care to ask?
I have no questions.
Okay. Do any members of the board have questions as witness?
Not of this witness, but is any portion of what we're talking about 19 feet from the sidewalk? And what is the height of whatever it is at the nearest point to the sidewalk?
Yes, at the point nearest the sidewalk, we are approaching at an angle. I'm sorry, I'm looking at the previous sheet. At an angle, we are 20 feet, 6.5 inches from the right-of-way to this point. From that point, everything drops back. That point is also, if I go to the front elevation, to the lowest portion of the addition. So that point in space is 11 feet 4 inches from grade. The addition itself from grade to ridge is 24.8. The house is 35.5. That's the 36 feet that I believe Ms. Beers was referring to. But again, this section here of that's the encroaching part, the expansion of the existing nonconformity, is a low one-story piece consisting of this small porch and this glassed-in entry area. And again, the addition is 24.8. I would also point out that the building height is measured to the mean slope of the roof. So, by right, the actual allowable height is, of this could match the house or go higher. We've deliberately created this scale to keep the accent on the existing architecture. We're actually, in recreating the one-story section here, we're actually lowering that roof, that existing roof represented by this dashed line. And then again, this piece is coming towards you, so that point of encroachment is 10, 8, 11 feet or so from grade. So the part that's encroaching is the lowest portion of the house, and by no means is 36 feet high.
Thank you.
So I stand corrected, it wasn't 19 feet, it was 20.
Okay. Thank you for your
From the
testimony. Any other witnesses on this matter? Please step up.
And sir, if you'll raise your right hand, do you solemnly swear testimony you're about to give will be the truth, the whole truth, nothing but the truth?
I do.
And your name, please?
Michael Beers, spelled the same as hers. Same address for now, so. And we're a little bit like Carville and Madeline, so I'm a data-driven sort of guy. And so
Excuse me, can you talk into the mic?
I'm so tall, you actually need a taller microphone. That would be awesome. Very much, okay. So I'm not an architect and I'm not a lawyer, but I have had historic properties in the past which I've restored. The reason that I'm actually sort of, and actually I'll go on the record, I'm opposed to this because I think that this issue of de minimis has not been met. In fact, the little bit of 79 feet they're talking about creates an entire structure that is now, outside of the original envelope and outside of the code. So you're basically compounding one error, which was the developer in 1890. And I'll put this up here. You can look at this. When you look down the street, this is actually looking towards Lancaster Avenue on Pembroke from the other side of the street. They basically jogged this whole thing out so they could squeeze one more house on there. And that's reflected in the property values, the fact that she paid $300,000 less than what the going rate is in there. So it's an inferior piece of land that has a lot of problems with zoning to begin with. So why would you compound this problem by now allowing a 79-foot, quote-unquote, de minimis to put something that's 20 feet from the curb, which is 1/2 of the allowable setback, which is what I think that is a little bit upsetting to my wife. Having an attached garage is great. It doesn't happen in South Wayne. So the beauty of Google Doc or Google Maps is you can do this, and I did this last night. I basically just scanned over the entire area and looked and see who had an attached garage and who had a detached garage. And it's actually amazing. And in fact, I actually take issue with what council said last time, that everybody does this in South Wayne. They don't do this in South Wayne, council, and you need to actually get the data. And the data, here's 3 pictures, and I'll give you the data. You probably won't be able to read the data, but I surveyed 24 properties, 21 of which I could see from Google Earth are detached or non-existent. There is none. The other 3, I can't tell. So that's not the majority of houses in South Wayne have detached garages. And so this doesn't fit historically at all with what you're trying to do. So it's not the way it's done here. So, and then finally, I think to tell you that you presented a little drawing, and I'm glad you did. I don't know if it was entered on the record, but you presented a drawing of where you could put the garage. And let me tell you, that's where people put their garages in South Wayne. They put them back away from the house where it's historically been, within the envelope of what they're supposed to be doing. And that's what's shown here. So this is a house at 301. This is the old Rooney house at 301 South Davids, a massive house. with plenty of space for children, and 3,000 square feet seems to be enough space to raise 4 children. I raised 5 children across the street, so I'm not really concerned about the burden here and the hardship. There's no hardship here. There's a 3,000 square foot house with 5 bedrooms that you're talking about. This is a detached 3-car garage, which meets all the setbacks, 40 foot, and it's a corner lot, so 40 foot on Aberdeen Avenue on the side yard, and 10 or 12 feet or whatever it is on the backyard. So you can do this if you want to do it. So I take issue with the argument made by counsel that all of this is de minimis, because it's not. You're shoving, the 79 feet allows you to shove, basically doubling the size of the house, at least the footprint, 20 feet from the curb. So I think that you have to take a careful look at that. And if you want to keep doing that, we can all get variances based upon the nuances of the fact that most of these houses were built way before the zoning laws. And now I think it's a time to actually put a stop to that. So I would actually respectfully ask that you consider that this is really not conforming, and I wouldn't magnify the non-conforming part of this. Thanks.
Thank you. 1 second. Any questions, counsel? Any questions on the board for this witness? Thank you very much. Are there any other witnesses for this matter?
Cheryl, and you promise to tell the truth, the whole truth, and nothing but the truth. And state your name for the record, please.
I'm sorry, yes, I do. Not very. Okay, this is a nice design. It's, and I appreciate the fact that you've kind of shrunken the bridge between.
Excuse me, ma'am. Just in
I-
connection with standing, it would be helpful to understand your relationship to the property, whether you're a
Okay.
landowner or a
When you
resident
showed
nearby.
the little houses in a row, there's this house.
If we could move the mic from underneath the newspaper, the papers. And if you could either give us your address, first of all,
411.
411, and are you able to indicate perhaps on that
Well, I don't think
diagram?
there's no picture of my house.
Okay, but give us a
But be
sense.
that as it may. There's this house, there's the Nichols house who spoke before. So I would be G. That if this were the star EF, I would be G.
Okay, three
Thank you.
three homes to the right of the subject property.
Right, yes, exactly.
To the right as we're looking at it. Thank
Yes,
you very
yes,
much.
yes.
Please continue.
Anyway, so this is a nice design. I appreciate the fact that you shrunk the thing between the two buildings.
Cheryl, put the mic.
Okay, I'm sorry, jeez. That you shrunk the distance between the two buildings. There's a kind of pattern that happens in South Wayne, which I think that Dr. Beers was referring to of, garage house and not attached. And that was all part of, in theory, the historic preservation ordinance, although Kevin will probably correct me that it doesn't say that now. But I think that when it was, and I also want to apologize for saying that I thought that the Historic Preservation Ordinance had included in it notification, and you corrected me about that. I think at the time that we were working on that ordinance, there was a presumption that it was in the zoning hearing code and would be met the same way. So it was our fault, and we were badly advised about it, but be it as it may. Let me see, now I've lost my train of thought. Anyway, so the thing is that this building is kind of monolithic. It's twice. A lot of people do that in South Wayne now. There's a nice house in the front. They build something that's about the same size as it in the back. But in this case, it's in the quote-unquote front yard. And so it's more visible. And it makes a very broad, this is probably not anywhere near your concern because this is more a historic concern, but it makes one broad swath of the facade on Pembroke as opposed to it stopping at the end of the house and having another building. So that's kind of difficult. I do think that it's going to be big. Having a second story on your garage, it does make it more than just a garage. And not that we don't have one like that in Wayne. But in this case, we're creating this. And I just think it would be better to have a separate room. When I had put an addition on my house 30 years ago, and I couldn't situate it the way that I wanted to because there wasn't 10 feet clearance between the garage and the house. And there's a ruling about that in the zoning code. And so I was later told that was for safety reasons, And so I wonder what's going to happen with this one, because there's no clearance at all, because beyond the garage, there's going to be a fence, right? So there's no, it doesn't have that access, unless I guess you come over, it would still have a fence. At any rate, so that's my point about that separation for safety. And the fact that this is just one big broad swath of building as opposed to the way that it's usually, and it's just more visible. Other people do it too, but it's more visible here. And that's why this is considered a front yard, because it is more visible. Thank you.
Thank you.
Sorry.
1 second. Council, any questions? No questions. Members of the board, any questions?
Yeah, I just have some perspective on this, having been on the Harb for 7 years.
Yes.
But we did run into that issue a lot, Cheryl, the massing and the
Right.
monolithic structures.
Right.
And in my reading of the zoning code, that's really not what we
Right.
have to consider
Yeah,
here.
I realize.
And maybe that's unfortunate, but,
Right.
I mean, there are rules regarding setbacks, and if someone doesn't meet those rules under the zoning code, they come and ask for a variance. And then we have to decide if there's an adequate hardship based on the particular the particular property and the measurements of the property, or at our discretion whether it's de minimis. So that's kind of what we're trying to do here. But I mean, I understand that issue on the massing, and it concerns me also, but it's not really something we consider
I
here.
realize that. And I do want to say that this is kind of a self-inflicted hardship.
Thank you very much.
Thank you.
Any other witnesses on this matter? Okay. Counsel, your case is closed. Can we move to discussion,
The
or?
board wants to hear more, legal discussions, but I think everything was submitted. We have 2 memos. We quoted case law last time about irregular lot size being one of the grounds for a dimensional variance, as well as property that was built long before current zoning code. And in terms of de minimis, again, the measure is the expansion of the existing nonconformity. The variance standard is the same whether you have an existing nonconformity or not. So we have one. That doesn't mean we have to meet any higher standard. So the 79 square feet I resubmit is a de minimis request.
1 second. Members of the board, you have received council's briefs in advance. Just checking, is there any particular component of those issues that you would like to hear anything about? Hearing none, thank you very much.
Thank you, board.
I'll open up to general discussion within the board, perhaps in advance of any particular proffered resolution. Any thoughts that anyone would like to share?
I'm personally not persuaded that there is a hardship here. And I also don't think that this amount of square footage is de minimis. So I'm having a hard time on both of those points.
Thank you, Matt. Thoughts from either in response to that or otherwise from members of the board? Hearing none, I then, excuse me, sir.
I was thinking before speaking. This is uncharacteristic for me, but I thought it would benefit if I thought before talking. I'm sensitive to the comments of the neighbors with respect to the goal, which I think in some or great measure we all subscribe to, of the notion of trying to preserve the character of our important residential areas in the township. Mindful of that, I do note that the Harb approved the original plans, and I'm not going to prejudge what they might do when they meet in August, but it could reasonably be seen that they might act in the same way in August, although I understand that they may hear other testimony from neighbors that they did not have the benefit of at their prior meeting. So the issue really of whether the addition complies with the sort of special architectural environmental nature of the analysis really is an issue for discussion and resolution at the HARB. We, as George noted, we're looking at some different things, and I'm sensitive also to the irregular lot size shape of this property. I think, in fairness, even if we were to deny the relief that has been requested by the applicant, there is still going to be a substantial addition to this property because the homeowner is well served by a skilled professional. They will make it work somehow. And this may be a little smaller at the end of the day, but to the extent that you were thinking that you would have the ability to preclude the homeowner from constructing a significant addition, I don't think you're going to get there. The de minimis argument is not one that I have completely ruled out in my mind right now. 80 square feet is rarely de minimis, but in the totality of the analysis, I certainly think that we have a property owner that's willing to work to try to get to a resolution that all stakeholders can be comfortable with. And to the extent that it preserves a property and improves a property, which the HARB has said they're on board with, I'm not ready to say that 80 square feet isn't de minimis. And personally, I think that the argument of hardship is a less winning argument in that I still think that things can be moved around sufficiently so that the existing nonconformity is not expanded.
Thank you. Couple members of the board who either, feel free to speak up.
The way you started reminded me, and Harry Truman once answered a question saying, "I don't know what my position is on that issue because I haven't started talking." There you go. And I feel like that a little bit, but I think I am sensitive to the irregularity of the property itself. I think that's a hardship. It was a hardship 100 years ago. It's a hardship today. It'll be a hardship 100 years from now. That's not going to change. And I think if this lot was a regularly sized lot, they'd be able to do this. They probably wouldn't even need our permission. So I think there is a valid hardship, and it's not a high threshold on a dimensional variance for hardship.
I guess just to add on what I was saying, not that I'm necessarily trying to persuade you to my position, this could be designed another way. I mean, this is all for a mudroom to connect the garage nicely. So I don't know that this is necessary on this lot or to achieve even an attached garage. This is just the way that the owner wants it to be done. It can be done another way.
Mr. Hirsch?
I'm the newest and least experienced member of this board and have been impressed with what they have said. That does not seem de minimis to me, but it does seem like the hardship issue of the site is important, and it also seems like the design that was done was done in a reasonable way. So in terms of a self-imposed hardship, I don't really see it as much that way. That it just looks to me like there's a hardship that's being imposed upon a reasonable design for this property, and that it seems to me that to me personally is at the moment persuasive.
Mr. Chairman, I I do not see this as a self-created hardship. I mean, this is a lot that's been in existence at least since 1890, and the self-created hardship is, you do something like subdivide and then, create an undersized lot, something like that. But this lot's been around for at least 125 years, and I don't think that there's a self-created hardship issue here.
Before I solicit a resolution, I want to thank the property owner for the adjustments they made to the plan. I want to thank the residents for having come out and shared their perspectives with us, which is always very helpful. Would anyone like to propose a resolution for our consideration?
Mr. Chairman, I propose that the applicant be granted the relief sought in the application from the requirements of Section 280-20.c on the basis of a hardship on this subject property, and that they be permitted to proceed with construction as reflected on the revised plans that have been presented this evening.
Before I solicit a second, I have one suggested addition and a question. Is it within our authority to include in any approval the condition that the promised removal of the rear shed occur?
Oh, absolutely.
Okay.
And they've agreed to that on the record, but yeah, absolutely.
Would you welcome an amendment that
I would welcome
clarifies
that amendment, Mr. Chairman.
Okay. So we have a resolution which has been proposed and clarified. Is there a second to that?
I second.
I now just, so we have the resolution, which is to authorize relief based upon the hardship, not based on de minimis. With that before the board, is there any specific discussion that any board members would like to offer? Okay, my comment is that I am persuaded that the relief should be granted, and I think that it is significant that if granted and with the removal of the shed, my understanding of the testimony is that the total nonconformity on the lot will actually diminish, which I think is of significance both in terms of the use of the property and also I think potentially is of legal significance. Going to call for a vote now. All those in favor of the resolution say aye. Aye. All those opposed?
Me.
Okay, the resolution passes 4-1. Thank you all very much for your participation. Thank you. The second item on our agenda is Appeal 2970. This is the Garrett Hill property. If the folks involved in Garrett Hill could approach, and I'll read the public notice here. Appeal 2970, the applicants Ryan A. and Sarah E. Caffrey, property located at 50 Garrett Avenue in Zone R5, seek a variance from Sections 280-105A and F and 280-4B as to parking space, and any other relief necessary from the code to construct the driveway and parking. Are you Mr. Caffrey or counsel, or both?
Mr. Caffrey.
Okay. Now, what you observed was a matter being presented by an attorney. You don't necessarily need to worry. We'll lead you through the formalities. That being said, please introduce yourself. I would suggest that you both be sworn in here at the beginning, and then we'll go from there.
If you both raise your right hand, please. Do you do solemnly swear or affirm the testimony you're about to give will be the truth, the whole truth, nothing but the truth? And state your names one at a time.
Ryan Allen Caffrey.
Sarah Caffrey.
Mr. Caffrey, please proceed.
Sure. Good evening, Board. Thank you for your time tonight. Again, my name is Ryan Caffrey. I'm the owner of 50 Garrett Ave. I'm here with my wife, Sarah. We've owned the property for about almost 8 years, and the matter that we're asking for this evening is we'd like to construct a driveway on the property. The total square footage would be 322 square feet to allow for two car parking spaces. And as stated in your synopsis, we're asking for relief from 280-105A and F, primarily in regards to front yard setback, as well as the minimum right-of-way distance, as well as 280-4B, which defines the minimum parking space requirement of 9.5 by 20 feet, which part of the area does not meet that, part of it does.
Mr. Caffrey, we probably ought to label your exhibits.
They should all be labeled,
Are they
other
all-
than the site plan, I believe.
They are all labeled?
Yes, the ones that I have,
Also an index, I'm sorry.
Yeah.
okay.
Okay, never mind, yeah.
I'm sorry, please continue.
No problem. So I guess before we go to the site plan, just if we could quickly go to A3-1. So just to give an overview of the property, the subject property, 50 Garrett Ave, is right here. If you're not familiar with Garrett Ave, it's one of the older streets in Radnor. Most of the properties were built around approximately 1900. Pretty much everything's in a regular lot. They're all, very skinny, approximately 40-foot width, and very deep, going back about, 250 feet. So all irregular in terms of current R5 minimum lot requirements. So our property's here, and we'll walk through some of the neighboring properties on the street that have similar driveway as we're proposing. Flipping ahead to A3-2. So in the upper right here, this is a front view of 50 Garrett Ave. The proposed driveway, you could see on looking at the picture on the left is 54 Garrett Ave. That neighboring property has a driveway similar to what we propose, and the driveway would be, adjacent, abutting that driveway, running up a portion of the side of the house. Again, you can see a few pictures of the front of the house here. Bottom left is the property to the right, 46 Garrett Ave and 44, which you can see the existing driveways. And then the bottom right, another angle of 54 Garrett Ave.
I'm still a bit disoriented, so bear with me. Your home, if you go back to that one, your home is the upper right-hand corner?
Yes, with the green shutters.
Okay, fine. And the proposed location, as we look at that picture, is to the left?
To the left, correct. Where
Yeah.
you see the SUV here, that's the neighbor's driveway. It would essentially be
Okay.
connected to that driveway.
Thank you.
Yep. And then A3-3, this is just a couple shots of the street in front of the property. If you're not familiar with Garrett, it's a very narrow road. It's not as wide as you would expect for a typical two-lane road that would be built today. It is a two-lane street by definition, along with parking on the one side of the street, as you can see in the picture here. Effectively, what you have as cars are passing by, it's a fairly heavily trafficked road, and it's kind of a 1.5 lane road. Cars need to sort of pull to the side to let each other pass often, especially when you have cars parked, as you would see here. So we can shift to the site plan here.
The only relief you are looking for is the relief for the front yard. You're not you don't need relief for impervious or anything like that, do you?
No, that's correct. The minimum or the maximum impervious coverage is 40%. We're existing at 12.7, and we would be increasing it to 16%. So well below the impervious coverage limits. So just looking at the plans here, the bottom left is blown up version. It's a little bit bigger for you, but as you can see here, like I said, it's 322 total square feet. It would allow for pulling in 2 cars. At the maximum, the portion closer to the street is 9.6 feet wide, going back 22 feet from the sidewalk, and then it gets more narrow on the side of the house, 7.2 feet, and then the proposal is to extend that another 15 feet for a total length of 37 feet approximately.
So that will accommodate 2 vehicles as opposed to 1?
Correct.
Neither version 1 nor version 2 exists now, correct?
Correct. It's just grass and nothing paved.
So, you're proposed that you have 2 proposals, but you prefer version 2.
Correct. We're asking for version 2, which is the greater area of coverage, and the extended driveway, as I labeled it here, does not meet the minimum width of a parking space. So that's why we have version 1 just as an alternative, but we are asking for version 2.
And the effect of this would be to be able to take 2 cars off of Garrett Avenue.
Correct.
If the board approves version 2.
Correct. So under the zoning, all residential is designed to have 2 parking spaces. We have none, as you can see currently. The parking on Garrett Ave is always a tough situation. There's minimal parking. Based on the congestion of the street, if every one of these houses had 2 cars, for example, there's not obviously room to fit all that on the street itself. So by approving this proposal, it would allow for 2 cars to be removed from the street, and it would not affect the current on-street parking that's in front of the house. The distance here between the current neighboring driveway of 54 Garrett and the driveway at 46 Garrett is approximately 69.8 feet, and by reducing that square footage, the footage by 9.6 feet, we'd still have 60 feet of frontage, which would allow for 3 cars parking, which is what existingly parks there currently.
I assume that the one hardship you would raise is that the lot is very, very narrow, and all the existing improvements are lumped at the front on the front.
Right, that is correct. As you said, the house is, the minimum front yard setback is 25 feet. The house is existing at 15.1. Minimum side yard are 10, and we're as short as 4 feet on the other side of the property.
What's the current use of the property?
It's a residential single-family home.
Is it a rental or is it?
No.
What kind of distance would you have from the proposed space to open the driver's door vis-a-vis your neighbor's parking area if there was a car there?
In terms of either area or the more narrow section?
Yeah, I mean, address both of the potential spaces.
Well, the front section, which is wider, the minimum parking space definition by the code is 9.5 by 20 feet, which is met by the front section. The average car width in general is approximately 6 feet, so there'd be adequate room there to open doors. And then you do get more narrow as you go into the extended portion at 7.2 feet. So, while it is tight, it does allow for a car, and, depending on the car situation, a smaller vehicle could fit there, at your discretion, not a larger pickup truck or something, would be tight, but at least, you have the option if it fits.
You have shared with us, it looks like 1, 2, 3 letters of support?
That's correct.
Okay. Could you, I'm just going to give you these address, maybe you can go to the
I
photograph
can pull it up.
of the neighborhood. Okay. And I guess somebody's making that clear. Okay. Point to where your home is.
We have the red dot.
Okay, the
right
red
here.
dot. The first one I'm looking at is the Sullivan's 46 Garrett.
So that is the neighboring house on the right from the street facing, which is right here.
Okay. Bennett 39 and 41.
That would be the two homes directly across the street here
Okay.
and here.
I'm sorry, I turned my head. Do it again one more time. That one.
That's two homes directly across the street,
Okay.
right here.
And
39 41.
Sarah Pilling 29.
Sarah's house is at the
Your head's
end right
blocking
there.
it.
Shetland, sorry. Right
Okay,
here. On
fine. Okay. I don't want to get you off track. Is there anything else you want to present to us?
Sure. So this is just an overlay of the property. You can see, again, the congestion of the street. I've got small inset pictures. And I don't know if you need to see all of them. You can flip through them in your packets. But this is Exhibit A-5-1, just to show that the proposal would be in conformity with the existing layout of the street and the existing feel of the street. You know, all of these, most of the driveways would not be, they're all non-conforming, existing non-conforming due to the age of the property prior to the code. But as we said, 46 Garrett and 44 are the neighboring properties on the right side. We have across the street with the letter of support previously entered at 41 has a similar driveway. On the other side of the house, we have 58 Garrett. Both of these driveways are also similar. And in total, on our half of the street between the R100 bridge cutoff and Lancaster, there's 28 properties, 20 of which have a driveway, 8 do not. Most of which would have similar nonconformity in terms of the right-of-way setback as well as front setbacks.
Okay. Thank you. Do any of the members of the board have a question for any question of Mr. Caffrey?
Yeah, Ryan, so your neighbor, that's going to be the adjoining driveway, have we heard from them?
That's a rental property, so I haven't spoken to them directly. It's formerly a student rental, now a regular non-student rental, but I have not had the chance to speak with them directly.
Just to foreshadow, is there anyone in the audience who intends to speak to this matter? Okay. Other questions for Mr. Caffrey? Okay, if you could have a seat for a second.
Do you move that your exhibits be made part of the record?
I'm sorry?
Do you move that your exhibits be made part of the record?
Yes. Okay. If there's anyone else in the audience who would like to speak to this, if they could come up, please.
And if you raise your right hand, you do solemnly swear or affirm the testimony you're about to give will be the whole truth, nothing but the truth.
Yes, I will.
And state your full name, please.
Sarah Pilling, it's S-A-R-A, no H, Pilling, P-I-L-L-I-N-G. I live at 29 Garrett Avenue. I've lived in my home for 34 years, so I've seen a lot of things come and go. I did a little bit of measuring between Lancaster Pike. So I'm on the other side of the street from Ryan, closer to Lancaster. Actually, Chetwynd Drive goes next to my house. So the street is 25 feet wide, and we only have parking on one side of the street. On Ryan's side of the street, there are 22 dwelling units. 8 have no drive. Therefore, they have to park on the street. There are 14 driveways, but of those 14 driveways, there are more cars than the driveways can hold, so 3 of them have additional parking permits to park. On the left side of the street where I am, there's commercial up to Chetwynd Drive, and then there are 10 homes. 7 have a driveway, 4 don't have a driveway. So we're parking a lot of cars. If you know the width, and if John, I know, drives it, I suspect you may from time to time, we sort of play do-si-do up and down the street. And the reality is, I knew Miss Rita, who owned the home that Ryan and Sarah bought. They never had a car at that house. She used to take her little cart and walk to the Acme, which is now the CVS, every day. So it's not like this is a normal. It actually, if you gave this relief, it would do the street a favor because it would get 2 more cars off the street. Now, Ryan mentioned the house next door at 58 was a student house. And thanks to the due diligence of community development, it is no longer a student house where they had 4 to 5 cars that did not all fit in the driveway. And we have another student house up the street. It has no driveway. And of course, it's supposed to have 2, but the truth of it is it doesn't. It has more, and I'm sure that community development will do its best to get them off the street. We have a lot of rental properties. Those which were student housing are now becoming regular rental properties. So ordinarily, you might say no, but I think in deference to them to be able to park near their house, particularly as they have a little child, any future person who lives there, they're going to need to have 2 cars. Garrett Avenue was built at a time starting after the Civil War. I think Miss Rita's house now, Ryan and Sarah's house, is the oldest surviving house on Garrett Avenue, although it was changed quite a bit, and then they bought it. There were no cars. So we're trying to make a silk purse out of a sow's ear. And the traffic is horrendous on Garrett Avenue. There was a movement when we did the Garrett Hill process to make Garrett Avenue one-way in order to relieve it. It didn't go through. The neighbors at the other end didn't like it.
One way toward Lancaster or the other way?
Well, that was what they never could. Ideally, they'd have broke through another street at the back of the properties up to the bridge, but nobody wanted that because they didn't want to give up property. It just became intolerable, and we just have to put up with it. I am amazed at the volume of traffic.
Sarah, thank you for your testimony. Members of the board, are there any questions?
Sorry. Any questions?
Thank you very much. Would anyone like to start with a resolution, or we want to start with open discussion?
Mr. Chairman, I would move that the applicants be granted the relief that they've requested in their application in accordance with the plan that has been presented here and their testimony.
Making clear that includes the 2 parking spots.
That's correct. That's for the 2 parking spots.
Yeah.
1 small car and 1 larger car.
I'll second.
Okay, we have a resolution offered and seconded. Quick point of clarification with council. Do you believe you have enough on the record in connection with hardship to develop your artful order and opinion?
Yeah, well, this actually could be approved by order because there's no opposition, but if there were opposition, I have enough on the record to develop the hardship.
Okay. All right, so any discussion of the motion? Seeing none, I'll call for a vote. All those in favor say aye.
Aye.
Aye. None opposed, 5-0. You'd be a lawyer. Congratulations.
Good job.
That's not meant as an insult.
You don't want to be. Okay, next item, the presenters could step ahead while I read this into the record. Appeal 2971. The applicant, Mainline Hospital Realty Corp., properties located at 804 County Line Road and 201 South Bryn Mawr Avenue, and both zoned C1, seeks relief from Section 280-122 dot C, paren 8, close paren, small a, close paren, of the zoning ordinance pertaining to height and area requirements for directional signs in commercial districts, and any other relief necessary to install directional signage.
I don't plan to testify, but this is
Counsel.
Hi,
Or you
good
can use the
evening.
handheld, whatever you're comfortable with.
Yeah, this creates a
The
lot of
handheld
noise.
may be, it's, I know it ties up one hand, but it's up to you.
My name is Caitlin Maselli. I'm with Riley, Riper, Holland, and Colagreco. I'm here tonight on behalf of the applicant, Mainline Hospitals. We'll have two witnesses, Nicole Battaglia of Stantec and Ian Goldberg of Cloud Geshen. I do have pre-marked exhibit packages if I can hand them up at this
Yes,
time.
please.
Please. Thank you.
As I mentioned, I'll have two witnesses. We're here tonight in connection with Mainline Health's proposal to install 3 what we call wayfinding signs in Radnor Township. They're essentially treated as directional signs under your zoning ordinance. But we propose installing them along the Wawa property. There will be 1, and along the Bryn Mawr Thrift Shop property, we're proposing 2 signs. In connection with those signs, we need variance relief as to the height and area of the directional signs. So the witnesses will go into a little bit more detail, just generally in terms of what the purposes of the wayfinding signs are. But Mainline Health is installing these signs throughout the community, basically to direct vehicular traffic to the hospital, to the emergency room, to the parking. So it's really just a safety mechanism in order to allow vehicular traffic to navigate that area well, and be able to identify the hospital, especially people who may be in an emergency situation, in order to clearly see where the hospital is, where parking is, things of that nature. So in terms of the exhibits, the first 3 exhibits I will just cover. They will not be addressed with the witnesses. Exhibit A1 is just our zoning hearing board application and cover letter. Exhibit A2 is the zoning ordinance incorporated by reference. And Exhibit A3 is the cover letter we sent to Kevin, along with copies of PS Forms 3877, which is just proof of the notification. And the remainder of the exhibits will be covered through witness testimony. So I will call the first witness, Nicole Battaglia.
You raise your right hand, do you solemnly swear to tell the truth, whole truth, nothing but the truth? And state your full name and spell your name, please.
Nicole Battaglia. It's Nicole Battaglia.
And Nicole, what is your position with Stantec?
I'm the project executive for the Bryn Mawr Hospital Campus Master Plan construction.
And what is your relationship to the applicant, Mainline Hospitals?
So we're basically acting as the owner's rep, so we're on site and we're there to manage the design and construction activities for the project.
And have you been authorized by the applicant, Mainline Hospitals, to appear this evening?
I have, yes.
And we have marked as Exhibit A4 a letter of authorization from Mainline Hospitals. And are the properties that are the subject of tonight's hearing located at 804 County Line Road and 201 South Bryn Mawr Avenue?
That's my understanding.
And is 804 County Line Road presently owned by Bryn Mawr Hospital Realty Corp?
Yes,
And is Bryn Mawr Hospital Realty Corp an entity that is affiliated with the applicant?
it is, yes.
And has the applicant received authorization from Bryn Mawr Hospital Realty Corp to proceed with this hearing for the property?
Yes, it has.
And what we have marked as Exhibit A5 is a letter of authorization from Bryn Mawr Hospital Realty, as well as the deed for that subject property. And so the other property that is at issue tonight is that located at 201 South Bryn Mawr Avenue.
Yes, correct, yep.
And is that presently owned by Wawa?
Yes, to my understanding.
And has the applicant received authorization from Wawa to proceed with the hearing and for the location of the sign on its property frontage?
Yes, it has.
And that is marked as Exhibit A6. That is a letter of authorization from Wawa, as well as the deed for the Wawa property. And did you direct the preparation of Exhibit A7, which is titled Proposed Vehicular Directional Wayfinding in Right-of-Way Aerial View?
Yes.
And so this exhibit is actually part of A1. It's a larger package that was submitted with the application. For purposes of the exhibits, we just kind of broke them out into separate exhibit numbers. So this is A7, but it is sheet 2 of the wayfinding package. And using Exhibit A7, can you briefly describe the locations of the subject properties and the signs that are going to be on those properties?
Sure. So 804 County Line Road, where signs 1 and 2 are indicated. So it's basically the northwest of the intersection of County Line Road and Bryn Mawr Avenue. And then sign 3 is at 201 South Bryn Mawr Avenue, so basically the Wawa property. So it's located at the corner of Bryn Mawr and County Line Roads.
And can you just briefly describe what Mainline Health's wayfinding proposal is?
Sure. So Mainline Health, Bryn Mawr Hospital, they're pretty much committed to ensuring safe and efficient wayfinding measures. So they have a comprehensive approach to the wayfinding, which is indicating the need for very strategic placement of signage to help guide vehicular traffic to emergency parking and the hospital main entrance itself.
And is the applicant here tonight in connection with variance relief needed for the 3 proposed signs in Radnor?
Yes.
And that is all the questions I have for Nicole. The majority of the testimony will come from Ian in terms of what the signage design is.
I have a question. I don't know who it would be for, but if you can point out to me. So sign number 1, I imagine it says, make an immediate left. Is that what the idea is? Is there a driveway over there?
Yeah, I think the actual design of the sign, Ian will testify to. That does have arrows indicating which direction is emergency, which direction is parking. But we will get to the design, and you can kind of see what items will be on the sign.
Any other questions of this witness? Thank you. I'm sure you'll be available if we need you.
Solemnly swear to tell the truth, whole truth, nothing but the truth.
I do.
And state your full name, please.
It's Ian Goldberg, I-A-N, Goldberg, G-O-L-D-B-E-R-G.
And Ian, who is your current employer and what is your position?
Cloud Gesson Associates. I am currently a senior designer, associate senior designer.
And can you briefly describe your background and professional experience?
I have 20 plus years environmental graphics, wayfinding design, planning.
And have you previously testified in zoning hearings as to relief pertaining to environmental graphic design and planning?
Yes.
Please use the mic.
And are you familiar with the subject properties and the applicant's signage proposal?
Yes.
Are you familiar with the applicable regulations of the Radnor Township zoning ordinance?
Yes.
I have marked as Exhibit A8 Ian's CV. I would offer him as an expert in environmental graphic design and planning.
No objection. Fine. Thank you.
Ian, did you oversee the preparation of the wayfinding package, which was included as Exhibit A1, and the individual sheets of which are marked as separate exhibits?
Yes, I did.
And were you involved in the overall planning of applicant's wayfinding signage proposal?
Yes.
And Nicole already touched on this, but can you briefly describe what the purpose of the wayfinding signage is?
It's basically for safety and to direct vehicular traffic safely to the garages, the emergency room, and the main entrance.
And using what we have marked as Exhibit A9, which is the diagrammatic wayfinding signage, or sheet 4 of the package. Can you briefly describe what the general design will be for each sign?
Sure. 1 and 2, which are along traveling, I guess, south, or I'm sorry, east on main County Line Road, or 1 and 2. consecutively, and 3 is the location in front of the Wawa location, all of which are trying to get people to the main entrance in the parking directions.
And so, as you testified, 2 of the signs are going to be located along the Bryn Mawr thrift shop property.
Correct.
And is that location for sign 1 depicted on Exhibit A10, which is location
yes.
1 adjacent property?
Yes, it is.
And so that is just a photograph showing the property that sign 1 will be adjacent to. And then Exhibit A11, location 2 adjacent property. Does that show the property to which sign 2 will be adjacent?
Yes.
And why is the applicant proposing the signs in these 2 locations?
There are, basically, there's the 2 immediate, they want to make sure that everyone makes that left onto Bryn Mawr Avenue safely. 1 and 2, noticing that the 1 arrow has an up and a left. That's really to make sure that people do not turn mistakenly or cross a double yellow line mistakenly into the main entrance to the cancer center, which is right there. We want to make sure people go forward and then make the left at the light. And then at that point, making sure sign number 2, that everybody gets in a left-hand turn lane in appropriate time to make that initial left.
What's the distance between sign 1 and sign 2?
Let's see. Do I know that? Let me see here.
Is it on the engineer?
Yeah, I think it's on this one. Sorry. Let me just. It's on. I think it's on the back of this one. Right.
So this is what we have marked as Exhibit A14. This is the engineered site plan.
Let's see. 2 and 1. Yeah, 120. I'm sorry. It's a little more than 125. It's about 140 feet or so.
And then is the location of the sign that's proposed along the frontage of the Wawa property, is that further depicted on Exhibit A12, which is location 3 adjacent property?
Yes.
And so again, that's a photograph depicting the location of sign 3 and then that it's adjacent to the Wawa property.
Yes.
And to the best of your knowledge, does the pole for this sign already exist?
It does. It's still standing. Panel does not. Panel is not on that sign.
And what we have marked as Exhibit A13 is a photo of the Wawa property taken in March of 2016. And so this photo depicts that the pole for that sign is there, the sign face is not. So Ian, is the applicant proposing to install a new sign face on this pole?
Yes.
And why does the applicant want to maintain the sign in this location?
I believe that, well, this is to make sure that people would go immediately straight on down Bryn Mawr Avenue for the emergency room and the parking development as they're crossing over County Line Road.
And are all 3 of the signs going to be located in the street right-of-way?
Yes. Yeah. 2 and 3, I'm sorry, yes, 2 and 3.
And so sign 1 is going to be outside of the right-of-way?
That is correct.
And sign 2, if you look at the engineered site plan, which is Exhibit A14, that gives the dimensions for the encroachment in the right-of-way. And so is sign 2 going to be approximately 0.67 feet inside the right-of-way?
That is correct.
And sign 3, which again, the pole is existing, is that pole located inside the right-of-way?
Yes.
And that's approximately 1.33 feet.
That's correct.
And what's the justification for locating sign 2 in the right-of-way?
Trying to get the sign panel and sight lines appropriate as someone travels down County Line Road to make sure that it is in the sight line of vehicular traffic. So it's really important to try to push that panel as close as you can to the road, keeping it the face of that particular sign about 2 feet or 18 inches from the curb line, so that our trucks and things like that don't hit it. But trying to get it in that kind of sweet zone, if you will.
And are there visual obstructions to the location of sign 2?
Not where we're locating it currently.
But if you were to locate it outside of the right-of-way, would
Yes.
there be visual obstructions?
Yes, there's an electric pole and a few other signs there, so we want to make sure.
Counselor, what right do you have to put them in the right-of-way?
So the applicant is working with PennDOT. They are PennDOT roads to locate signs in the right-of-way. We did not identify any particular zoning ordinance section that prohibits the location of directional signs in the right-of-way. We understand that we would still need an acknowledgement from the board to allow the signs to be in the right-of-way. And so that's why we are bringing that up tonight.
Well, I mean, I'm not sure that if the consent of PennDOT is necessary, I don't see that we have the, requisite, consent to proceed with the signs that are in the right-of-way.
And I think the applicant would be comfortable with a condition that would, condition the approval on PennDOT, acknowledging that the signs will be located in the right-of-way.
I mean, normally, we want the consents now. The other thing, though, is anything this board gives as an approval can't operate to affect the rights of PennDOT. And PennDOT could say, take them down now. PennDOT could say, take them down 5 years from now. I mean, but I'm very troubled that we don't have the approval of PennDOT now to put signs in their right-of-way.
And again, as for sign 3, the pole is existing for that sign, so that is more of a non-issue. For sign 2, again, I think the applicant would be comfortable saying that if PennDOT is not accepting of the location in the right-of-way, that the applicant would, have to move it outside of the right-of-way or come to some other resolution on that issue, that it would be PennDOT's jurisdiction ultimately.
Well, I mean, we could, if it's moved to another thing, then, we'd have to come, you'd have to come back. I mean, we can't say, put a sign here, or if PennDOT tells you to move it, move it. We have to know the precise location of where the sign is for the approval.
Right. The only technical variance relief that we need is the height and area, so that would not change depending upon what PennDOT says. The location inside or outside of the right-of-way would, but again, we're not sure of any setbacks in the ordinance that requires a certain length of distance from the right-of-way.
Yeah, but when we approve we approve a variance, it's as to a specific location. We can't give you an airdrop zone to move things around as PennDOT has. But again, the Wawa sign is on the Wawa property. That's not in the right-of-way.
It is in the right-of-way, yes.
Okay, are any of the signs not in the right-of-way?
Sign 1 is not.
Okay.
And sign 3, the Wawa sign, what was on that pole? Or was the pole simply erected on the anticipation of something else?
It was very similar to what you're seeing here. So this was the Lower Merion system, wayfinding system, happened to be on that particular sign.
And what was the approval procedure for that sign?
We did not, that sign has been up for 10+ years. I'm not sure what the process was for there. Yeah, I think it was 2001, I believe.
Please keep your voice up.
2001, I believe, is when those were installed, somewhere in that neighborhood.
And it was a hospital-specific sign?
It was a yes, and it was, and it had Lower Merion, other destinations from Lower Merion actually on it as well.
Was that maintained by Lower Merion?
Yes.
And that sign had been maintained by Lower Merion.
But it's in Radnor Township.
That's correct.
I'm sorry?
I understand your issue, John, which we will consider as part and parcel of our discussions here. Can you help me with why you concluded this was not an off-premises sign under the code?
In speaking with township staff, it was directed that we treat this as a directional sign and consequently get relief as a directional sign. And we do have the authorization of the property owners, so it's not technically advertising a business conducted on that site, but we do have the authorization from them for the location on those particular properties.
Well, I mean, presumably a billboard owner has rights, has authority from whoever has the property to put a billboard there. I don't think that's dispositive on the question.
It's different, though. It's a directional sign.
And the sign really is more of a directional nature. It's not advertising, you know, a business that's conducted off-site. It's more just a safety issue, getting vehicular traffic to the hospital. So quite frankly, it wouldn't make sense to put these on Mainline Health's property. In order to serve their function, they need to be off-site.
Kevin, do you have any perspective to share on that?
We did spend some time looking at this. That was one of the issues that I raised early on, along with the right-of-way issue. But then looking at the available options, we felt that the directional sign fit more in line with what these signs were, given the description of those signs on the displays.
And while I'm sure it's part and parcel of this, just again, for simplicity to the board, describe to us the size and height of the signs that could be utilized, setting aside the right-of-way issue, under the code without variance.
Yeah, and the next part of the testimony will go into what the proposed height and area is.
Fine, we'll let you proceed.
Okay.
Thank you very much.
Okay, Ian, is the applicant requesting variance relief to permit all 3 signs to be taller than the permitted 3 feet?
Yes.
And so for each of those signs, can you give approximately what the height is proposed for each sign?
Sure. For sign 1, it's approximately 10.61 feet. Sign 2, approximately 11.84 feet. And for sign 3, it's 13.92 feet.
And that pole is already existing at 13.92 feet? Okay. Please describe the justification for the height of the signs.
We want to make sure that we have clearance over pedestrian traffic and try to keep it high enough. Typically, as we do, around 7'6" typically is the line we'd like to kind of hang those things at, really because to keep people from putting stickers and things like that on, or reachability issues. So we really want primarily to clear pedestrian traffic. Also, it's perfect for the vehicular sight line as well.
Clear pedestrian traffic?
Well, so they can walk underneath it if necessary.
13 feet?
The bottom of the actual panel hangs typically about 7'6". So here you're 7'6". So really, we're trying to clear pedestrian traffic from underneath it.
What is the height that's as of right?
It is 3 feet for a directional sign.
3 feet. So that doesn't let anybody walk. They have to walk around that. Is that correct?
Right.
And also from a vehicular standpoint, you'd be looking pretty much through your dashboard.
So anytime you want to go above 3 feet, you have to come here for a variance?
Correct.
Okay, thank you.
Is the applicant also requesting a variance for the area of each of the signs?
Yes.
And is that to permit each of the signs to be larger than the permitted 4 square feet?
Yes.
And can you again go through each of the signs and what the proposed area is?
Sure. Sign 1 is 8.6 square feet. Sign 2, 12 square feet. And sign 3 is 15.8 square feet.
And again, what is the justification for the area of those signs?
Really for the messaging and appropriate size for scaling, copy scale, et cetera.
And for visibility of motorists?
Exactly.
And in your opinion, does the size, scope, extent, and character of the variances promote the harmonious and orderly development of the zoning district?
I do.
And do the proposed modifications constitute an appropriate use consistent with the character and type of development in the area and surrounding uses?
Yes.
Will the proposed modifications substantially injure or detract from the use of surrounding property or the character of the neighborhood?
No.
And will the modifications have any effect on other properties?
No.
Will the modifications have any effect on traffic or highway?
Positive effects.
Insofar as it'll direct vehicular?
Safety, directing traffic in the correct direction, hopefully alleviating some of that pressure at that intersection.
Will the modifications have any effect on public services and facilities?
No.
Will the use of the property adjacent to the properties that are subject to this hearing be adequately safeguarded?
Yes.
And do the proposed modifications protect and promote the safety, health, morals, and general welfare of the township?
Yes.
In your opinion, are there unique physical circumstances which justify the zoning relief?
Yes.
And what would that be?
Again, making sure that these panels in the sight line, et cetera, so that they're viewable from the vehicular standpoint.
And do you want to talk a little bit about the intersection, that it's kind of a tricky intersection to navigate?
Sure. Flip this over. Sure. So we have County Line Road, Bryn Mawr Avenue, and then Railroad Avenue here. So it's really the kind of the 5 points is what we're calling it. So as one person travels south, I guess it's east, on County Line Road, that they encounter sign number 1 really telling them to go forward and then right, because we don't want them making immediate lefts, forward and left, making immediate lefts into the entranceway, crossing the double yellow line and into the entranceway for the cancer center, really trying to get people to bypass that, where the second sign kind of helps them realize that they need to get over into the left-hand lane, come down and make that left-hand turn. And then sign 3, as they're traveling this direction, Bryn Mawr Avenue, just reconfirming that they need to go across Bryn Mawr Avenue to reach the destinations, parking, emergency main entrance, drop-off, et cetera.
And in your opinion, can the signs be installed in compliance with the zoning ordinance's height and area limitations and still serve their intended function?
Yes. I'm sorry, no. No.
And essentially limiting it to 3 feet in height and 4 square feet in area would in fact present a vehicular danger?
Yes, it would.
And has the hardship, in your opinion, been created by the applicant?
No.
And are the variances requested the minimum necessary to afford relief?
Yes.
That's where I have a question. Can we go back to the panel with the 3 signs on it, please? The intention is to construct these, and I'm focusing on the 2 taller of the 3 signs. The intention is to construct these as they're shown on these panels?
Currently, yes. There will be there's still some design as far as colors are concerned, but
Okay.
beyond that.
I'm just talking now about the dimensions of each of the 2 taller signs. There's empty room. Is that in anticipation of additional development on the campus, that you know you're going to have to point people to a building that doesn't exist? Or why do you need that extra space?
Really just, it's accounting for possible additional messages in the future. So we don't have to redesign the sign or gain square footage necessarily.
Yeah. And this is, again, as council alluded, this is the exercise that we engage in determining what the minimum relief is that is required to satisfy your purposes, yet not go beyond what we need to as a board. So there's no current immediate need for other wayfinding other than what is presented on these 3 panels?
No, not at the moment.
Okay.
Not at this time. So technically, we could bring it down in size, yes.
Question, in terms of the current condition, am I right in recalling that as you proceed, I guess it's south or east on County Line, that there is currently one of the traditional blue H hospital signs that goes to the left? It's a make the left to the hospital.
Excuse me, I can't hear you.
I don't know that the sign's arrowed, but there is a blue H.
Okay, thank you.
There's signage along Bryn Mawr Avenue. Is this similar to the signage that's along Bryn Mawr Avenue in front of the main entrance to the hospital that's along Bryn Mawr Avenue?
We're working on a complete sign system for Bryn Mawr. So anything existing will not be there.
Okay.
They'll be switched out for taller, very similar signs that you're seeing here.
Now, is the Wawa signpost up already? So this exhibit says that it's not up? So are you saying that the exhibit,
Which exhibit is that?
the one that you had of the 3 signs?
This one.
If you look on the
So that's
notes-
demonstrating just the sign face for that?
No, note 3.
Yeah, so that really just should be clarified to say that the panel of that sign has been taken down. The pole is still existing.
Okay, now the panel size here is roughly 6 feet by 3 feet. Are there any signs of that size currently up in the area?
Yes, well, not in Radnor Township, but in Lower Merion Township, there's a slew of them, actually, so it's all over the township there.
But I mean, at Bryn Mawr Hospital.
Yes, there will be taller signs
Is there
located.
one in place now that we could kind of get an idea? Because 6 feet by 3 feet seems like an awfully large sign.
Right, not as of yet.
But I'm not an expert.
Not as of yet.
There's no sign around Bryn Mawr Hospital of this size? Is there a sign of the size of the middle one there, the 4.5 feet?
No,
by?
none of these are up yet. They're
So but are there signages in Lower Merion part up for the hospital, for the new MOB or whatever? Are there any signs that give you a perspective of the size? Because these sizes seem awfully large just sitting here.
And I believe the signs are going to be consistent with what is proposed in Lower Merion. So the size, height, area, all of that will be consistent as between Radnor and Lower Merion.
Right. So the new signs will match basically the sizes of the Lower Merion Township system, as far as width and height are concerned, square footage is concerned. So that was one of the stipulations from Lower Merion that we had to meet.
And is their sizes the same as these sizes on these signs?
Right, so it's all consistent.
Has that all been approved by them?
Yes.
Has Lower Merion approved signs that are in state right-of-ways?
Yes, they've done it in a numerous places. As you go up down 30, for instance, if you travel up that way, you'll see the maroon signage, directional signage as you're coming up.
But to perhaps clarify his question, did they approve signs in right-of-ways before the state authorized the placement of the signs in the right-of-way?
So I think Lower Merion has a somewhat different process. They did not need zoning relief, correct me if I'm wrong, but they did not need zoning relief for those signs. Their ordinance has kind of a different mechanism for wayfinding signage. So it was a somewhat different process, so it's not really apples to apples comparison.
But Lower Merion did approve in advance of PennDOT's approval, so we were offered a conditional approval.
And if council wants to answer this, fine. Could you again articulate the hardship that exists?
I think the purpose of the signs is really a vehicular safety issue, that we need to direct people who may be in an emergency situation to the hospital facilities. And so to put in a sign that is 3 feet tall, 4 square feet in area would not serve its intended function. That would actually create a safety hazard to motorists trying to identify the property. So really the scale of the signs and the height of the signs is designed to allow vehicular traffic navigating what is a somewhat complicated intersection with the 5 points to be able to clearly see where they're going to get to the parking, to get to the emergency room, and really serve that safety function.
Could you put the intersection, picture of the intersection back up there, just for at least my benefit and maybe others? So these signs are sending you to the main entrance and the emergency room. Where are they?
Emergency rooms about here.
So that's north of that.
So when you get up that high, you have to make another left and turn in?
That's correct. We have there's additional in the
okay.
Additional messaging as you move up.
Yeah, because just going back to Bill's point about a directional sign, I'm reading the definition. It says, a sign designating points of ingress and egress to a property, normally located at such points of ingress and egress. Now, I look at this ordinance, and a directional sign being 3 feet off the ground, I mean, that sounds useless to me. All I can think of is, the arrows when you're going to a McDonald's drive-in or something. But other than that, it doesn't seem to me that a sign 3 feet off the ground is going to be able to give anybody direction. So I can't understand the ordinance to begin with.
Well, that would be at the entrance, the actual entrance to the facility.
Again, the point is,
so at a
are these
3-foot
directional
level-
signs? Or are they billboards?
Huh?
What I'm struggling with is whether these truly are directional or if they're simply off-premises
Because they seem
signs.
pretty far from the actual ingress and egress.
Well, they're directing ingress and egress, is, presumably to the property that they're on.
No, but the definition says normally located at such points of ingress and egress. That's the second part of the definition of directional sign.
Yeah, which suggests that it's the property. You know, that property that with ingress and egress to that property.
And the 3-foot height makes sense then, because thinking of the McDonald's example, a 3-foot sign when it's at the property is useful.
That's right.
Yeah.
I'd like to suggest that we save some of our discussion for that portion and allow the applicant to complete their case and share additional perspective.
That is the extent of the direct testimony that we have. In terms of the not being directional sign, I think that's really the closest category that seemed to fit for what's being proposed here. This is somewhat of a unique situation, that a lot of businesses don't have the need to direct people from, further off-site. So this is somewhat of a unique situation, and I think that is maybe the best category in the zoning ordinance. And that's what we, came to the conclusion with staff, and that's consequently why the application was filed considering these as directional signs.
Thank you. Do members of the board have questions of the applicant or their witnesses?
Yeah, I just want to ask this question. On the notes to the signage there, the top one says it does not meet some code and will need PennDOT review and approval. Could you tell us in what way it doesn't meet this 2012 code?
To clarify for the other members of the board, I think we're reading from Exhibit 9, tab 9, and the note on the top right-hand corner of the tab 9 exhibit.
The one way that does not meet MUTCD current code is the scale of the copy. We were particularly suggested from Lower Merion that we meet all specifications from the original system that they have. So we went ahead and did that. So that basically the copy is, I believe, about a ½ inch short of the within code.
So the lettering is not as wide as the code would want?
Or height. It's the X height,
The
so it would be the height.
Any other questions?
Let me understand this. Lower Merion, as to a sign that is situate in Radnor Township, is proposing to tell us what the sign should, or tell you what the sign should look like.
We just, no, what we're trying to do is make everything consistent so that
I understand that. Right. But I just want to make sure I understand the direction that you got from Lower Merion.
So with regard to this particular sign, so I think that it's a design interpretation, and in an effort to make a comprehensive wayfinding system to just keep it aesthetically consistent. Truth be told, I think that Mainline Health would.
Yeah, I'm just wondering how the tall one is consistent with the other two. I see how the other two are consistent with each other, but I don't see how the Lower Merion one is consistent with anything.
Sure, and I think that's a very fair statement. And I just wanted to mention that none of these signs are intended to be self-serving for the hospital. It's really to improve the community access and inform and offer clear direction so we can, find our way to the hospital safely.
But Lower Merion Township, it's not giving you direction as to signs in Radnor.
No.
And maybe this question is coming from me because I'm a trademark lawyer and I see that you've got the logo branding on the signage. But it looks to me like possibly when these signs were designed, it was an important goal to have that source identifying feature, not just that there was a hospital, which is a public service, but that it's Mainline Health's hospital with its logo. And I'm looking and just ballparking, but both of these signs, I think sign 1 could probably be cut by a quarter in surface area, and sign 2 could probably be cut by a full third if that source identifying service mark isn't on the sign, right?
So potentially, Ian, from an artistic perspective, I'll let you to respond to that. But I think one of the important components for Bryn Mawr is that traveling down County Line Road and or Lancaster Avenue, there are other hospitals along the way. So expectant mother, somebody needs to know that they're going to Bryn Mawr Hospital, so that was part of their key logo, and not,
It's rather small.
it's small, but. You can make it larger.
They would like that.
Any?
You have space on at least one of them.
Okay. Any other questions from the board for the applicant or these two witnesses? Okay. Is there anyone else in the audience who wants to speak to the item? Okay. Thank you. Have a seat because we may have questions for you. All right. First, we'll have some general discussion. In terms of the issues that are sort of part and parcel of this, there's the right-of-way question. There's
I would interject, there is no right-of-way question. They're only asking for two variances. One is area of sign, and the other one is height. So they're not asking for anything regarding what's in the right-of-way.
just, then I'll clarify my comment. To the extent we decide to proceed, we will need to do so with appropriate specificity so that any intervening decisions by PennDOT regarding its right-of-way that might impact the location of the signs clearly flow in terms of what we're doing here. I guess I'll share a perspective personally, which is that I think that it's clear that to the extent this is a defensible request, it's peculiarly associated with the hospital use. And I think if the applicant in front of us was Wells Fargo Bank saying, we need people to know that we're off over here, and they have to turn to get to the bank, and there's other banks, so we got to say Wells Fargo Bank because we want to make sure they can find the bank, I think it would be self-evident that that's not a hardship. So I, the question here has to do a little bit with how we analyze the health system as a business versus a public, if not a treasurer, at least a public institution that may warrant some more flexible consideration. That's a general comment. I'm anxious to see if we have other thoughts to promote discussion.
Yeah, I would ask the solicitor whether it is a fair or an unfair reading of the code to try to put these signs in something other than a directional sign, namely an off-premises sign.
I think that directional signs mean directions of, ingress and egress onto the property. I don't think it's a directional sign. Also, in terms of hardship, they're required to show hardship peculiar to the property, and there's a recent case on that, means the Wawa property or the thrift shop property, not the hospital property.
So does that then, it has to be some kind of a sign under our zoning code.
Mm-hmm.
Does that then put it in off-premises?
I think it does, and if I'm correct in that, you're looking at a use variance, not a dimensional variance.
I think I think I would disagree with you on that. They're good points, and I read the definition, but it is the purpose of it and the function of it is for ingress to the emergency room. I think as a general matter, the purpose of the zoning code is to promote public health. And I think these signs would certainly fall into that category. And I know if in certain situations, if someone's rushing to an emergency room, I'd like to know they'd be able to find it. That's my thought.
I don't mean to add that I'm not sympathetic to good directional signs, you know. I've had to go to the hospital a few times. I mean, from that perspective, I'm very sympathetic to it.
Luckily, I haven't. That's why I didn't know how to get in.
Yeah, I guess really the concern, and certainly in this context, and with the intended purpose for these signs to direct members of the public to a hospital, it's not the same as there are other banks along Lancaster Avenue, and we want to make sure that they get to Wells Fargo. There are other, you know, if you're at Lankanaw and you're looking for Bryn Mawr, well, sorry, I don't think these signs are going to help that much. But notwithstanding the definitional jujitsu we're going to have to do in terms of considering the application, I think the purpose is well intended. So don't misunderstand my apprehension about the grant of relief. I continue to struggle with what exactly it is we're looking at and how much of a leap we need to make from what this definitionally is to what we can grant relief on, and what kind of relief we need to grant. Because as the solicitor points out, if it truly is an off-premises sign, then you haven't asked for the relief that you would need, and secondarily, the type of relief that you need is a larger hurdle that you need to satisfy.
I would like to add that while technically the right-of-way issue should be beforehand, I can get an order there, so to speak, that, you know, as long as they have to get PennDOT's consent and we can't affect PennDOT's rights and la-da-da-da-da, I would get the decision to the same place as if PennDOT proved it up front.
Again, you're not compelled to speak up, although somebody will be compelled to offer a resolution to bring this process to a logical conclusion. I will pause.
Another question for colleagues on the board and the solicitor at this point. To the extent that we take the approach that this is a directional sign, I'm always concerned about unintended consequences, and the next applicant that we see come in with a request. Are we able to craft relief that makes particular note of the public service purpose that is sought to be achieved by these signs, and still be on defensible ground the next time someone comes in and says, well, I have agreements with other people that are directing folks to my location. I happen to be a commercial location, but hey, you know, the hospital is a commercial location too. Can we thread that needle and focus an order on the public benefit aspect of the relief being granted, as opposed to simply this is the most effective way to achieve the purpose that the applicant has brought before us?
We could do that, or we could say less. I mean, right at this moment, nobody has opposed the application, and unless somebody does oppose the application, I could do it as an order. And you know, no one case is as legally precedential to another, and frankly, this one does have a very different set of reality from the Wells Fargo versus the PNC example. And I think that if anybody were to come in and say that, in a future case, I mean, we could say the board's responsibility, it's not precedential, and also that there was a compelling public need. I'm a little bothered by also the advertising. It was advertised as as a directional variance, and if it's not, would we have a Glengarry adequate publication problem? That would be your risk. Glenn, in other words, could this be appealed beyond the 30 days by anyone?
I'm sorry, I'm not, it was advertised as a directional?
It was advertised as a directional sign, and if we conclude it's not, and you need a higher quantum of relief, have we advertised this sufficiently? And I say you have other relief, but there's a risk there, and the risk is twofold. One, is the board comfortable proceeding with the advertising as it is? And two, you're getting a decision. If you do get a decision approving it, you would get a decision that is subject to PennDOT. You would get a decision that if PennDOT says no, you'd have to come back. And frankly, the Glengarry, Luke v. Cataldi gauntlet would be your risk.
And I think the applicant understands that. As to the PennDOT issue, the only sign that really is that issue in terms of PennDOT is sign 2. That's the new sign in the right-of-way. Sign 1 is outside of the right-of-way. I think the applicant still is of the opinion that these are best classified as directional signs. I think of off-premises signs, typically in the context of billboards, I think that's usually how they're intended. These, are not obviously billboards, and the only real messaging on the signs is directional in nature. It's, an arrow pointing to emergency room, pointing to entrance, pointing to parking. That is all directional in nature. In terms of the definition of directional sign under your ordinance, as one of your members pointed out, it says normally located at such points of ingress and egress, and not exclusively. So I think, again, this is a unique circumstance. The hospital obviously offering a public service. I think, again, the messaging on there is directional in nature. No, it is not located at points of ingress and egress, but that is not particularly required by your ordinance. And so I think the directional categorization is still, the best category absent an amendment to the ordinance or something of that nature.
Yeah, personally, I'm not sure about that, but others, I could see somebody else coming out the other way. And again, I do think that whatever the grades on, an argument are, this is very different from a Wells Fargo sign on another property.
I guess the thing I'm thinking about, because I'm glad you brought up the point about the word normally in there. It does make me feel a little better about it. But where do you draw the line about how far away the directional signage can be? I mean, in theory, you could say, well, gosh, there's an emergency. I'm 5 miles away. Where's the hospital? I mean, could you really still call that a directional sign?
Well, it's across the street from the building, so.
No, and I understand in this case, but if another hospital or this hospital comes back and says, well, we have the same issue, it's a mile further away, what do we do? Is it a directional sign?
Well, again,
I'd say no.
Because it's
this decision
normally
is not legally precedential.
And
for
I
anybody
understand
else.
that, but I mean, we're sort of interpreting the definition of directional signage in a little bit of a loosey-goosey way. So how loosey-goosey can we go?
I might have a little bit different take on some of this. I'm a little bit not sure why there needs to be 2 signs on County Line Avenue, that I'm a little bit concerned that there's too much signage along the street, but with all of the other places, and that I'm not sure why Bryn Mawr Hospital needs 2 directional signs to point their way into the hospital. And the other one in front of the Wawa, that from where that sign is, you can see Bryn Mawr Hospital, and you can see the sign at the corner there that could on Bryn Mawr Hospital property direct you there. So I'm not saying you don't need the sign, but I just wonder why there's a sign of such size there that would be there. So I'd love to hear more about it. I'm sorry if I'm kind of going off on a tangent for you, but it just seems like that Bryn Mawr Hospital is like getting a lot of signage that kind of might detract from the ability of everybody else to do what they need to do with their properties.
Well, typically we had one. We added the second because there was a lot of complexity, again, about this main entrance here that would basically make people turn across a double yellow line and into, we want to force people, if we had a display, we had a left arrow here, that would basically people would, some may think, to make that immediate left into the cancer center. So we wanted to bypass that and then get people down and then away. The second part of this is that there's a three lanes here. There's a turning lane, so we want to make sure that people had enough time to get over into that third lane to make that left. More of a safety reason than having it at the last minute, do one of those. So really, that's why we have the two signs there.
Yeah, and I guess my question is that I can see the benefit to the hospital, but I wonder if it's not to the detriment of others, and I just wonder how many people making that left turn are really going to the hospital versus everybody else who's doing everything else on the street. So that's what my point is that could one sign take care of the vast majority of that issue and not need as much signage as you have there? Because, there's a nice new restaurant there where sign 2 is, and there's people are sitting outside eating on the patio and all that kind of stuff there. So to then put a sign of the size of that 2 to point people in the emergency room, I guess my question is, how necessary is that sign? Right. Because by that point, people ought to be in those turn lanes if they're going to make that turn.
We're really just trying to really emphasize the emergency there,
yeah.
To make sure that anybody that's under stress could just see it and turn and move over into that direction, make that left.
Okay, and what about the size of the sign in front of the Wawa? Is that a concern to anyone else to have a sign that's that big when you have Bryn Mawr Hospital signage right there at the corner of Bryn Mawr and County Line?
Right, we made it that large because sometimes, I don't know, you're talking about the ID sign, I guess, gateway sign that's sitting there now? Is that what you're referring to?
Yes.
Right, so that sign's set fairly low, and when there's a lot of traffic, you don't even see that sign from across the street.
Well, could you raise that sign then so that it could be?
The ordinance only allows us from the other side of the road, only allows us to kind of raise it up a few feet, or not even a few feet, a few inches really, and that's what we're planning on doing. But at the same time, there's trucks that come through there, so it's not always evident as a ID sign from that side of the road. So it's really a reconfirming message.
Okay, well, this is it's a somewhat complicated circumstance, and we need to I think move on. And the three options that occur to me are to approve with such clarifications or qualifications as the majority of the board may conclude, to refuse relief. I guess we would also have a practical option if we should decide to provide some guidance and ask the applicant if they wanted to consider continuing to next month. I'm not sure that's always a good thing to do because there'll be, first of all, it's not next month, it's 2 months. And there'll be more items coming down the road. So there's 5 of us, so the good news is we're not going to have a tie vote. So we got to, I need somebody.
Get the ball rolling here.
Mr. Chairman, if I could, if the board is so inclined to consider, because we do have, we have a request for a design of signs, and I know there's been some questions for the style of the signs and the size. Obviously, the size is part of the dimensional relief being requested, but we do have a design review board, so if you were so inclined to grant relief, that you also then consider design review board having a final say as well, so that they also have the purview. This would be in front of them as a matter of policy for all signs to go in front of the Design Review Board, that they would also take whatever maximum threshold and then possibly bring it down from there on the size, style, and layout of these signs.
Appreciate you sharing that. Thank you.
Yeah, thanks. Well, I will make my motion to grant the relief requested with no amendments or conditions, because if they ever have to move the sign, then they've violated the relief we've given them. So I don't think we need any amendments, but that's my.
Okay, so a motion has been made. Is there a second?
I'll second.
Okay, so we have a motion which has been seconded, and
Can I just say that I do think that any approval ought to say that, you know, we're just doing the zoning code. Other township ordinances aren't, you know, involved, and other, you know, any approval rights by PennDOT and so forth are not altered. But I mean, you know, just do it that way.
And I think for purposes of this discussion of the resolution, we can take that as a presumed portion.
I'll accept that. I was just going on a notion that it goes without saying.
Okay. All right. So
Not here, George. Nothing goes without saying here.
Okay, so we have a resolution. Any discussion of the board?
Just quickly, I'm not convinced it's directional signage. I don't think that it looks like that's going to make a difference here tonight, but I think the fact that the code calls for directional signage to be 3 feet high kind of hints at the fact that off-site signage like this cannot, by definition, be directional signage. So that's my rationale. I can't vote yes.
Anyone else? Before I speak, is there anybody else who wants to share perspective? I am not going to support the resolution. My sense is that the signs are too big. And I think that there is an argument to be made regarding having the opportunity for some signage. And I understand the issue that was raised about directional and the guidance there. And I think that they're somewhere between 3 feet and perhaps what has been proposed. I think there may be something between the requested square footage and what is provided for in the code that I would be comfortable with, but I'm not comfortable with these. Yes. Not argument. If there's a quick point of clarification, I'll let you make it, but not argument.
Right, and I think the applicant is comfortable with the size of sign 1 and limiting the other 2 signs to that size. Is that correct, Nicole? So all sizes could be the size of sign 1 in terms of the square footage.
The square footage being 8.6?
Yes. Is that a new application?
No, it's a condition that they've, you know, reduced their signs. I mean, the applicant has accepted on the record that each of those signs will be the same as sign 1, 8.6 square feet.
Yes, correct.
So that's.
But the appearance of the third sign will mirror the Lower Merion treatment as opposed to the other 2.
Yeah, I think what the sign looks like is design review.
Okay, I don't care.
All 3 signs.
8.6 square feet.
George, are you amenable to amending your resolution to that effect?
If that's the consensus, yes, I think.
Does the extra stuff get cut off the top or the bottom? In other words, that the sign 3, where do you take the excess above 8.6 square feet?
The bottom.
The bottom?
Yeah. I think if the text is the same, we presumably could defer that to the design review board and the applicant. All right, so the resolution before us is to approve with the clarification that the area of each of the proposed signs, each individual proposed sign shall not be in excess of 8.6 square feet.
You
Subject.
need 6 feet
Huh?
square, it's 8 feet 6 inches, right, square, or 8.6?
Square feet.
It's 8.6 square feet? 8.6 square feet.
0.6 square feet?
8.6 square feet. Okay, that being said, all those in favor of the resolution say aye. Aye. All those opposed?
Nay.
I'm sorry, Bud, I did not hear your vote.
I voted aye.
Okay. Resolution passes 4-1. Thank you for your patience. Thanks for coming out tonight.
Thank you very much.
Mr. Chairman, now that this is behind us.
We're off record and the meeting's over?
Yeah. This is just what you've identified tonight with this question is something I think you should encourage the commissioners to direct that we look at our ordinances, because wayfinding has become a modern trend. In Villanova, we know, will be bringing in requests for wayfinding signs, especially because of the parking issues and the new parking garage. So your encouragement to us would be appreciated. And this is a perfect example where you really had to struggle to figure out how to fit it into our existing codes.